Hello guys, and you're very welcome at X-Founders channel. X-Founders is a Web3 bootcamp backed by Polygon, Avalanche, AWS, Mastercard Crypto, and other companies. And today we have a very special session. So we are joined by Ruslan Usmanov, founder at tx.legal, expert in Web3 law for many years, and Orrin Campbell, founder of Question, a Web3 version of Google Forms. And so today our aim is to basically give the floor to Orrin as a Web3 founder who has a lot of questions in the legal field that are going to be directed to Ruslan. And so, let's get it started. Ruslan, first of all, I'd like to ask you a few words about yourself. So how did you end up in crypto? What is it that fascinates you mostly about the field? So just a few words.
Yeah. So as for my relationship with crypto, it's like not I choose crypto, but crypto choose me. I always like the stuff like that. So when I study university, I very be like of ideas of anarcho-capitalism and so stuff like that. So when I studied this field, I find out about crypto, and some guys from my city, from some guys from my school, even invite me in their fund investment venture fund. So first of all, when I studied university, I started to work as an venture capital analytics, and we in 2017 2018 tried to enter some projects and invest in them. So at this time it was kind of easy, and it was quite successful for the fund until the end of 2018, when the crypto market was crashed. Also, at the moment, I ended my bachelor's degree in law and started to work in various companies like PwC. I worked with Cointelegraph, I worked with ICO Rating, and so on. And then my previous partner from the fund invited me in the firm. So let's go make a legal firm, as we know crypto from the business side and we know the law. Also, he had an experience from the PwC, and we started our own legal firm. And since 2020, we help with crypto projects with legal issues in the space.
Awesome. Sounds amazing. I mean, we're very happy to have you with us today and generally in the bootcamp. Orrin, I mean, the same question to you. Could you please introduce yourself and your startup?
Of course. So hello, everybody. My name is Orrin Campbell, born and raised in New York. I went to NYU, and I'm building Question. Question can be seen as the Web3 version of Google Form or SurveyMonkey. We work with businesses to create paid surveys. They can fund it in cash and or cryptocurrency. And then the survey respondents earn this cash or cryptocurrency for completing the survey. And this is all done from our proprietary data wallet. So the business and the user interact from data wallet to transfer these survey answers. I was involved in crypto back in 2017 as well, during the ICO days. I followed it through the 2018 bear. And then in 2020, when DeFi summer started to pick up, that's when my interest got renewed and I started building Question. And so it's been a 2.5-year journey. We've done accelerators with Filecoin, Near Protocol, Verizon, and we're basically going to be launching our public beta in the fall.
Orrin, and like in terms of legal, at what stage are you now with your project?
In terms of legal, I mean, like, I feel like since it's crypto and Web3, you kind of always need legal. Like, you can never get enough of legal, right? We have our own internal CLO, but it's always good to get a second opinion to see, how somebody else would go about this. And since we're dealing with data, since we're dealing with securities in the US, it's always good to just get a second opinion and just make sure that we're doing everything as compliant as possible.
Absolutely, absolutely. I mean, yeah, feel free to ask your questions that I know you prepared in advance, at least a few of them. Yeah, so the floor is all yours.
Thank you. So I'll kind of start with 3 general questions, and then we can kind of get more specific into my functionality as a business. My first question is, what's your unbiased opinion on AI generating legal documents like terms and conditions, privacy policy, user agreement, especially since you can reference similar companies and then, have the AI fit the output to your needs? And if you're not a fan of AI generating certain documents, how do you feel about using AI to create an initial draft and then getting a professional legal opinion on that draft?
So here we have 2 sides. First of all, I myself use sometimes ChatGPT for my legal work. For example, if I need some kind of draft contract, I first of all may create it to the ChatGPT, and then I give it to my lawyers. They create it more precise and make it more specific, and then we make it and go to the client this document. There are we have here two sides. For example, if you a startup and you need terms of use and privacy policy, and you know what your business contain of, on the stage where you have not so much of clients, and it's the measurement of the risks and reward. So, for example, new startup may use ChatGPT, make terms and privacy policy. But if you create this kind of document, it's better to consult with a lawyer, show them these documents, and have some kind of verification. I, as a lawyer, can use ChatGPT because I have an ability to verify these documents. But the startupper, for example, STO, they don't have such an ability. So it's better to verify. But in terms of costs for the startup, it's I think it's a sufficient option for the start. But if you have a lot of clients, if you have deep dive in the data protection laws, and you need to verify, and make specific document for your startup. So it's like a business and law answer,
That's perfect. Thank you. My second question is, what's the difference between a cryptocurrency and a virtual credit like McDonald's or Starbucks in their mobile application? Like, what defines it as being a credit? Is it that a credit can only be spent and received between the issuer and the user only, and not able to transact from user to user in a way a cryptocurrency can?
Mm-hmm. It's kind of difficult question because it's basically depends on how the blockchain is created. For example, when we have McDonald's credits, it's a centralized system. They have all their own data service. They always can change the rules. For example, if you create your own blockchain, it's can work like the McDonald's credits. So you can change the rules and so on. But if you, for example, use blockchains like Solana, Ethereum, Polkadot, and etc., so you cannot create your own rules. And if you create a token and it's have a fair market price, you cannot burn all the emission of tokens as the McDonald's can. So it's depends on the control of the system.
That makes sense. Thank you. My third and last general question is, what are your opinions on patents? Specifically, do you hear of large markets for the buying and selling of fintech patents? And then, if most businesses want to remain competitive and scale, does it not make sense to have a patent, since your competitor can get one and effectively put you out of business? At least the way the patents work in the US landscape.
It's a kind of hard question what I think on patents. Basically, the system was created in the 19th century, in the middle of the 19th century, something like that. So it's the development of the system. So, for example, you create an engine, and you you create an intellectual effort in this engine, and you need to protect your intellectual strength that you put it into this engine. But the patent now have some difficulties because, for example, fintech projects are created not like fintech projects sometimes they're about business. For example, the creating of patent for an engine, or for the plane, or for the method of how to fly, it's the separate from the creating of the method in the fintech and blockchain. It's kind of easy to round this patent. For example, you create a method, and the other guy see your method, and he make an addition in your method, add some kind of little addition in the method, and make it better, so he can create a new patent. It's not so useful in the space, but the lawyers make the money on patents, on registration of patents in the different jurisdictions. This is the main idea. So it's this system is needs to some changes, some development in the legal space, first of all, because a lot of things that we don't need patent to.
Ruslan, can I add something here? So like, but how different is it, like patent law, like an IP in Web3 compared to Web2? Because we know that now there's a trend towards like open source, right? So it's becoming more and more complicated in terms of protecting your intellectual property, something that you created and you like openly publish now in Web3.
It's not the question of the patent law, because even in Web2, for example, when you create technology open source, so it's open source, anyone can use it. For example, when you make your technology, when you make your method publicly available for all the people, it's not patent. It can't have patent security on this.
Mm-hmm.
So it's public available, you can use it. But Web3 projects, basically centralized projects, have their patents on their methods, on how they, for example, Binance have some patents on the methods, algorithmic methods that they use and implement. For example, if someone steal this method, they can easily to protect this method because they are created this kind of method. But for open source projects, it's not relevant at the moment.
Okay.
Yeah.
But what's like the general trend? So do only large brands tend to use patent law in any way? So like they ask for patents to protect something they created, or is it also quite spread among like medium size and smaller companies in Web3?
Small size, medium size.
So like startups, how usual is it for a startup to ask for a patent?
It's very unusual. It's very unusual, and the main problem when the founders don't understand the basics of the patent law, trademark law, intellectual property law. For example, we have there are three entities. It's like intellectual property. For example, every developer, every designer that create intellectual property are contributing to a company in intellectual property, and this IP should be transferred to your company. This the first entity. The second entity is a trademark. So for what is a trademark? It's a registration in the government that you have some kind of business name and can use this business name, make licenses on this business name, and so on. And third entity is a patent. For example, you create an absolute new method. You create an absolute new technology. You create something new that you want to, nobody except you can use this method, or you may give a license to use this method to some kind of other project. For example, if you can see their demand on this, for example, you create a method and you understand nobody wants to use this method. It's easier for my competitor to create like a new method, for example. It will be easier. It's not so intellectually expensive. So why to register a patent? It's no need to. For example, if you create a new processor or you create a new semiconductor, okay, yes, it's difficult. It's $1 million of research and development. But if you create something like for 2 days, no patent, no need.
Okay, so it's more about like material objects, and probably for anything like, as you mentioned, in fintech and in other fields, it's more about like creating this entire user experience, right? And like probably like growing your product through other means, and not really being very afraid of some new method being stolen.
Yeah. So if you have an idea that you can license your patent and you can commercialize this, and you are really afraid that somebody can steal it, yeah, okay, the patent is needed. And if this method is really new and revolutionary.
Okay, Orrin, did you have this question because this is something that you're considering, or just out of curiosity?
Yeah. I wanted to ask one more question on the patent. So I guess to get even more, we'll get now more into the specificity. So my company basically is patent pending in the US, UK, Germany, Switzerland, and Portugal. And basically it's a system and method for mining tokens with user data. So if somebody creates a system where you put in data and that data exports cryptocurrencies and or NFTs, we would have a proprietary mode on that in 5 different countries. We are in the final stages of getting published. We filed this over 18 months ago, so I understand how long the patent game is. If and when we get approved, do you think that there would be value in selling and or licensing this patent, right? Big companies like Coinbase already have like learn and earn type concepts that would be close to what our patent kind of covers.
As I'm a lawyer, not I'm a businessman and a lawyer, and you're an expert in your business. For example, I will surely know that it will be possible to sell the licenses when I already sell that license. For example, if you have a supply, if you have a demand, you have a supply. I don't understand at the moment is it will be needable for the projects, like for the other projects. The problem I see is that you created an technology, you create a method that people can mine tokens with their personal data. For example, they provide their data and they receive tokens. The problem here, already we have some kind of projects like this. So, for example, you contribute something, you contribute time, you contribute effort, you contribute your data, and you get the tokens, even airdrops, even some kind of projects that already provided this like this. Okay, for example, you will obtain a patent. You will obtain a patent. You know that the blockchain is a protocol. For example, some guy when developing a protocol, may take your idea, may take your method, not your code, but your idea, and create the kind of new Bitcoin that the guys who will have an ability to mine through their personal data. And what are you going to sue? For example, you even don't know who is the creator of Bitcoin at the moment. So, for example, the guy created and here's anonymous. Who are you going to sue? How you protect and how you protect your technology and your method? It's kind of in the blockchain space, you know, it's based on the sharing of knowledge, the democracy of knowledge and the methods. For example, if you created a proof of work or proof of stake and everybody should use it and you are encouraging guys to use it. Maybe it's more in a philosophical way and an economical way of the blockchain technology. It's better to incentivize some people to use the technology and maybe make it open source, but not close to one.
And what about one more question on this? What about, I understand kind of Web3, right? We have PancakeSwap, Uniswap, and we get all these derivative projects if something is seen as successful, and it's kind of hard to stop that with all these startups, which are in different countries, and how do you enforce that? But what about if and when we get this patent, selling it to a big Web2 player, right? Because they would want proprietary moat around this type of action. So what about selling it to a Web2 player who could enforce that patent?
Enforce. It's for example, my example on enforcing. For example, guy create a protocol. He is anonymous. The protocol is exists in the internet space. There's no company. For example, when we make a lawsuit as a lawyers, we need a defendant. Who are we going to sue at the moment? There is no entity. There's no person. Nobody. But people are using this technology. So guy created like yours, protocol, open source, everybody use, and you are not going to sue everybody.
Right. So basically, no matter who will be trying to enforce this patent, the consequences are the same. And so the conclusion here is that we can't simply replicate those models that exist in Web2 law, right? And just merely replicating them in Web3 doesn't make too much sense.
That's for sure. The problem that opens here is the problem of defendant. It's really big problem in the Web3 space. As you know, maybe from your experience, from your corporate structure, a lot of companies that create their tokens are open through the offshore jurisdictions like Cayman Island, AI companies, Seychelles, and so on. For example, you make a project and you sell the token. For example, on the soft contracts, you even didn't create your tokens and you need to lawsuit this company. Okay, you go to court, you lawsuit this company, you win the court, and you have the list of the court judgment, and go to offshore jurisdiction and trying to get your money back, but there's no bank accounts, there is no exchange accounts, everything on the non-custodial wallets, and you can't do anything. You can absolutely do anything. One thing only you can do it, go to the police or go to the SEC and try to sue on the regulatory level. Nothing else. There's no ability. A lot of bankruptcy here, a lot of companies, a lot of conflicts here in the Web3 space, but the guys can't do anything because everywhere is through offshores. No assets, no bank accounts, no nothing.
That's a good point. Thank you.
Yeah, sorry, Orrin. So Ruslan, does it mean that you never advise your clients to open a company in those offshore jurisdictions?
Always.
Always.
We as lawyers are based on 3 entities. It's law, lawsuit practice, and the best practices of the market. So when we deciding on where to create a company, for example, we need sometimes separate companies in different jurisdictions. Every company have their own target. For example, if we create a company for the token emission, it's usually offshore zone. Why the offshore zone? Because zero taxes, no administrative barriers, no problems. For example, BVI, Telegram, Layer 0, all the CoinList projects are structuring through the BVI, British Virgin Islands, and it's okay because it's for the projects, it's zero administrative barriers and easy to use, and it's okay. But when we are talking about, for example, incorporating a structure for the equity investors, for the IP, for the trademarks, for the patents, it's usually like non-offshore zones. It's like Singapore, Hong Kong, United Arab Emirates. It's like USA, Delaware, C Corp, for example, and so on, so on, so on. So it's basically when we are talking about structuring the Web3 projects, it's always depends on the risks associated with that project. For example, if we create risks associated with that business model and the markets where we're going to target. For example, if this is American exchange operator and they are going to operate through all the America. So we analyze the law, we analyze the legal practice, we analyze the best practices, and we understand that we need to create the company in the US with a token emission in the US if we need a token, for example. But if we don't need a token, for example, create exchange, we create a company, we go to SEC, we obtain all the licenses on the state level, money transmitted licenses, and so on, so on, so on. For example, if we are making a project that are outside the US, we make the other attitude towards the structuring these projects. It fully depends on the business model and all the markets where I'm going to enter.
Yeah, right. Orrin, and where is your company registered?
Wyoming. We're registered as an LLC in Wyoming.
DAO LLC.
You said what?
Just LLC or DAO LLC?
Just LLC, no DAO.
Just LLC. Okay. Yeah, Wyoming is kind of good option for the crypto. But I have one more point about the American jurisdiction. So everyone in the media, everyone when we have a consultation with the clients, so always said me about how they scare about America and SEC and so on. But from 2013 and until 2022, we have only 127 of legal actions from the SEC to crypto projects. Only 127. Half of them are against the scams. Half of them against unregistered security, unregistered exchange, unregistered marketing of security, and etc. So only 60 projects that were prosecuted by the SEC at the moment. It's not so much in the absolute numbers as we have the crypto projects. But if we take the jurisdictions outside America, it's like 1, 2, 3, nothing else. So the fear of a regulator is kind of very hyperbolized. Everyone is scary, but at absolute numbers, it's not so scary. But other point here is that American government is not decided on their attitude towards the crypto markets. For example, maybe you heard that the government body, I don't remember how it calls in English, sued SEC for their attitude towards the crypto market. And they have no opinion at the moment. And in the next year, the administration will change. And maybe they will have more light position to the crypto project. At the moment, in the legal space, in the from the legal side, it's like Wild West here. If you are okay, if you are doing good things, if you're a builder, if you're a developer, if you are not scammer, it's only a little, very little chance that you will by the bodies. But are creating a project, and this are going to America. Their regulators have all the, for example, you may heard, maybe you're from 2017, you heard about Ether Delta. Ether Delta. It was first popular DEX.
Okay.
Ether Delta. And they were persecuted by the SEC. They were, it was a fine from the SEC. And at the moment, SEC have the kind of light legal basis for destroying all the decentralized exchanges, but they don't do that because they do not because they have no rights. They have rights, but it's a kind of political decision.
That makes sense.
Orrin, and what's your experience operating in the US?
I mean, like exactly what Ruslan said, right? Like, I think it's been a constant consideration for us, given the obscurity around crypto, right? And the fact that we deal in blockchain and crypto assets, it makes us super conscious. So we want to make sure that we outline that our virtual credit is not a token, right? That only the users can receive it from us and spend it back with us. You can't have user-to-user interactions. And in addition, we basically created a data wallet, right? So the way that you can see Question is similar to OpenSea and MetaMask, right? So OpenSea is this interface where you find buyers and sellers, and OpenSea allows them to initiate the transaction from wallet to wallet. And so that's kind of how Question acts, right? So businesses create these surveys and the user completes it from wallet to wallet, and we're just the interface where they engage to limit our responsibility so that the user, we can point to the user and say they initiated that transaction, they initiated getting paid, they initiated that data transfer. So we can kind of remove the onus on us. And I think we've been constantly sculpting our business to keep these considerations in mind and remain compliant.
All right, so you basically chose the perfect formula for you and you're just sticking to it, right? Okay.
Exactly.
Okay. Yeah, very wise of you.
I won't be like make on myself a role of a legal psychotherapist in the space. So it's founders here. It's really a little things that you should fear for. We have a lot of clients since 2020, and a lot of ICOs, a lot of projects, a lot of builders, and we have zero problems at the moment because it's in absolute numbers. It's almost impossible for an average good faith project is to be prosecuted or some kind have a regulatory problem. It's like an informational noise. Media, CoinDesk, Cointelegraph, and so on.
That makes sense. I have a couple questions that we can just kind of rapid fire into. I have like 8 specific questions if we could kind of touch some of them. Does that work for everybody? Okay.
Sure, absolutely, Orrin. Yeah, fire away.
Thank you. So Ruslan, my first question is, in our specific platform, we allow businesses to fund surveys using smart contracts. And then users who complete the survey can interact with the smart contract and unlock the cryptocurrency. If certain cryptocurrencies are securities in the US, are we breaking laws by allowing US users to claim them? Even though it's not a sale, could it be considered as such?
So here as a lawyer, it's not legal advice. I should be here specific. But when you are as an intermediate between the transfer of securities, it's always a risks. Always a risks. So when you are intermediate of transferring the securities from one to another, you have a risks. Always have a
What
risk.
if I understand that? What if I'm not transferring it though, because it's the business who loads the smart contract and then the user claims it? We just basically charge the business to be able to load that smart contract. Can we still technically be considered transmitting?
For example, if you provide like services where you aggregate users and make a platform for surveys, but you not interact with the transfer of securities, and you not control of how the your client on the business side pays to your to guys who conduct service, so it will be okay. But it depends on if you have a security like that is already prohibited, can't use it. But if it's like an regulation, we don't know how to evaluate that. Okay, no problem.
So basically all of the 60 tokens that the SEC has said are securities, I should just stay away from them, right? Because in terms of serving US markets, right?
I should understand how you control of the choose of the currency of payment to from your business to your guys who conduct service.
So we basically have gotten grants to build on specific blockchains. So like Near Protocol gave us a grant, Polkadot gave us a grant, and so we integrate them as funding options. And so when the business creates a survey, they can choose, okay, I want to fund on Polkadot, they make the smart contract, and then when the user completes the survey, they can then claim it using their wallet themselves.
Yeah, who decide how to in what to pay? For example, I am a business, a legal firm. I need to conduct survey. I decide what I'm going to pay to my guys.
Exactly.
So if I decided through the ecosystem that, for example, it's on your wallets or on my wallets. This month
through your wallet. You fund, and you fund the smart contract, and then the user claims it. We don't hold that money for you. We just allow you access to that smart contract, and you fund it yourself, and then the user claims it. We don't want to be the intermediary.
Okay, it's not legal advice, but I see here it's a very low risks for you, very low. Yeah, based on based on the legal practice that we have.
Thank you.
Good news.
Yes. I'll ask another one. So in our specific model, we offer virtual credits for the completion of surveys. This credit is only issued by us and given to the user if and when they complete a survey. This credit can then only be spent in our digital marketplace for discounts, coupon codes, NFTs, and in-platform privileges. Can this credit be deemed a token or security? And more specifically, to get even more specific, when users complete a survey on their platform, they do it from their profile, which is a data wallet, right? And so each survey triggers a zero knowledge proof, which records survey completion. And so since the credit is technically cryptographically tracked, is that a security? It's not on chain, but we create these zero knowledge proofs as evidence that they've earned the credit. So I just wanted to add that cryptographic incorporation.
Yeah. First of all, on the question of security, when we are considering the word security, we are referring to the US security laws. And the US security laws have two tests: a test of Howey, test of Reeves. For example, if your token can be considered of investment of money or any other value to the common enterprise to get more money, it can be considering as a security. So if you for example, your guy make some survey and get the coupons, discounts, etc., 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 I here, as not legal advice, see low risk at first. The second, the matter of token. Token is the word. It's like means something like something in its as is. The token can be anything. For example, we can consider token as a capsule, but we decide what we are putting in this capsule and how we use it. For example, one token can be a security. One token can be a discount coupon. The second token can be a right for the property right. The fourth token can be like nothing, absolutely nothing, just token. For example, transfer of value, like Bitcoin. Bitcoin doesn't have anything in this essence. It's like just a token, just a token.
That makes sense.
So basically, in Orrin's case, because the users of Question, they do not expect any profit, right, from using this token, it cannot be considered a security. And also, it doesn't depend on the efforts of a third party here, because this is also one of the conditions of the Hobby test, right?
Yeah.
Okay, clear.
Thank you. We're on question 3. I have 8. So as long as we outline, we collect users' personal information. Okay, I'm gonna try and frame this. So basically our business is user completes a survey, the copy of their answers goes to the business and one copy goes to us, right? And so basically what I'm trying to outline is like, as long as we outline to the users in our terms and conditions and user agreement that, hey, we're taking this data, we might modify it, translate it, sell it, repurpose it, and use it to train AI models. And as long as we're not breaking local data laws, we can technically do what we want with the data within the scope of not breaking the law, as long as it's outlined in our privacy. Is that correct?
Yes. So your only borders is the borders of law.
Okay.
But not the precise knowledge of law, but its principle. Mm-hmm. So, for example, European law is mostly based on the principle. For example, if the judge will consider your using of the law against the target of creating this law, it may be considered as you will be fined.
Thank you. Okay. Oh, I guess building on this question, right? In our platform, each profile is a data wallet, right? I said you can see questions similar to OpenSea. We connect buyers and sellers, right? And so since the user is authorizing these transactions from themselves, from this wallet, and they have a zero knowledge proof that they authorize it, that also limits our liability as well, right? Because we can say, look, the user authorized this transaction, they have proof of this authorization, and they took that on their onus. That helps with the reducing of liability, right?
Liability on what matter?
Just I guess, in terms of misuse of data or illegally collecting data without user permission.
Right. It depends. It depends. For example, when he transfer his data to the business, and the question here, do you have some kind of process of onboarding the business? Do you check the business or something like that? Or any business can just connect their wallets?
Any business can connect their wallets, but internally we have different tiers. So if you want to be a verified tier, that's when we have to KYB you, which we do using Plaid, which is, a government verified agency.
You should here consider with your lawyer the question of the trans-country of collecting the information. For example, if you now take all information from the, sorry, I will take this topic, but it will be kind of precise, from Pakistani people or Palestinian people, collect all the information. And then the company that are gathering that information are from Israel, for example. It may be some kind of problems here or something like that. You should be precise here on the information that you are transferring. So when you are creating this kind of services, because you are encounter with some kind of sensitive data, it's very possible that it may be a problems on the, for example, governmental level. If your project,
how does Google Form get away with it, or SurveyMonkey, right?
Very, very big. If your project will be very, very big, will have problems, but they have the army of and the army of governmental pressure against that. So they they under pressure, and they create pressure because they have a very big strength in the field. So they can create narratives, they can create news, they can create something like that, and it's better not to mess up with the Google.
Okay.
Or Facebook.
Thank you.
Yeah. I want to add here that in your model, it's impossible to track all the corporates that are interacting with your service. But it's at the moment you have only a low risks of arising of that problem. You will face that problem if you will be very, very big. But when you will face that problem, it's will not be a question at all.
That makes sense. Thank you. And I know who to call at that point, right? Oh, I think that's a good question. So based on the understanding of our platform, do you believe that we need a money transmitter license, right? Based on what I've read, we act similar to Airbnb and Uber. In our specific case, when a business pays out in cash, we charge their account, place the money in our Stripe escrow, and make payouts to the user upon survey completion. Does that potentially need an MSB? I read this article which said Uber's providing a service for which we pay for using a stored credit card. They settle the funds into their account and submit a payment to their drivers on a weekly basis via HCH minus their fee. Their model is no different than a 1099 contractor being paid weekly. Does that make sense? And do you think that sounds like I need an MSB?
For example, in the crypto space, MSB is needed for projects like exchanges, the custodians that they have a money custodian. As we are taking into account that you don't have a bank account, everything is going through the Web3, through the blockchain, and you non-custodial provider. The question may arise on the discretion, on the where is the discretion of the money unfrozen. For example, you have an escrow account. It's like when the business comes to you, they froze the money, and when the service is completed, the money unfroze and go to you and to the users.
Exactly.
Something like that. And we here need to understand who is open the freezer. When you freeze in a centralized way, it may arise a question of MSB. I'm not some kind of expert here, but you should consider that risks. But for example, if you will create independent oracles, that will be a third-party blockchain participant that will be incentivized, for example, by tokens for their oracle, for their analyzing of survey is going well or not, and you will give a little commission. It will unfreeze you from the liability of MSB license.
Wait. I need you to could you expand a little bit on the oracle concept and like a potential use case of how I could do that?
For example, you may create a new entity in your blockchain. You have a business, you have users, and you have a party that will have a discretion to unfroze money. They will analyze the flow of the operations, and when they see that everything is okay, they unfroze money and money comes, and they will have only a little commission. And here you will have free of liability of the MSB in any sense.
And receive a partial fund. Can you explain to me why the incorporation of an oracle further distance us from the MSB classification? Like, what about that can be seen as
because of discretion of money, of unfrozen money. When the money is frozen on your contract, it's money frozen, and you decide in a centralized way, and it's create some kind of risk. As I stated previously, I'm not an expert here. It's not legal advice here. I only have some thoughts on this. And I see two ways. When you centralize, have frozen money, unfrozen money, you decide, you may not decide. It's not programmable. It's not an open source code. It's your decision. It's have risks. On the finance, it's financial institution regulations. Risks arise when you control money flow. But when not you control money flow, but in blockchain you have an infrastructure where anyone could connect to your blockchain and will on Oracle that will decide on whether everything is going well. You fully decentralized and no risk here.
Can I ask you one more question on this, just to see if our current setup could classifies this? So in our current setup, the user completes the survey, and then they get a zero knowledge proof in their wallet that they completed this survey. And then they redeem this zero knowledge proof to unlock the funds. Can that technically be considered closer to that Oracle situation, since the user needs this ticket to redeem it? And so based on that ticket, our system then unlocks the rewards if they have this ticket?
So it's in automatic way. It's reduced risk. For example, if it's not your discretion, it's the discretion of the algorithm of a code. You deploy a code and you don't change it. And this is how it works. And you do not control the money flows. The money flows fully programmable, and the code is always here and everyone can see it. So it's here almost zero risk of MSB.
Okay, thank you so much. And that was really insightful about the differentiation. 2 more questions. Since users are getting paid on our platform, should we issue a 1099 or some legal documents to help them file taxes? I ask because my next question is, do we have to, right? Obviously, we can code in exporting these files, but we also allow them to export their transactions as CSV. So do you think legally we should be providing them with these documents? And yeah, kind of just your opinion on that, since we are paying people.
Here, I'm not an expert in American tax law. So I only can decide here on my practice use of some kind of crypto project. Almost no one do this. So it's not. We as lawyers usually take the best projects with the best lawyers to understand how they structure the projects, how they're drafting their documents, to understand the best practice. And I almost no one uses.
Okay, thank you. And then
some more to come.
Last question. I'm just making sure it makes sense. I'm going to read it out loud if it doesn't make sense. I said, if we want to allow users to interact with our platform in these financial manners, granted that cryptocurrency is legal or acknowledged there. Basically, because we are an international company, right? Like people can make surveys in India or in Pakistan or Palestine. Do you think it's best that we should be contacting the local financial agencies in that country to make sure that our operations are compliant? I don't even know if we're going to get a response, but even if we do reach out, can we use that contacting if we end up getting sued later, or there's some legal dispute as like, look, we tried to do due diligence, we tried to reach out to your agency, but
no legal advice? No, never. I will explain my position on here. So, it's a very big legal uncertainty on the crypto space. And we interact with various jurisdictions, and we incorporate companies in a lot of jurisdictions. For example, in some countries, it's a really obligation to, for example, to inform the government bodies, tax bodies, that you have a separate legal entity in other jurisdictions. At the start of our legal firm, we should be maximum compliant with law, and we always communicate with government bodies. We have so much troubles when we're trying to be compliant, so much troubles. Really, it's pain in the ass when we are trying to be fully compliant. But when we decided that sometimes we will not inform the government agencies on some kind of activities, it's we are fully compliant in that jurisdiction, but we not informed, for example, in the domestic jurisdiction that we have companies. It's much easier to work, no problem. Or even if you have not even it's a plus when you work in a crypto space, because there is no banking communication between countries, and it's no problem here. Yeah, this first point. The second point is the administrative pressure. For example, we analyzed how all exchanges, all top tier, top two, tier 2, tier 3, all the exchange structuring. For example, Binance have an ability to be compliant in all the jurisdiction from the money point of view. They have an ability, but they, for example, in a lot of countries have some licenses, but they do not obtain that license, because when you get the license and when you inform the government entity on your existence, it will create more pressure more on you in future. For example, they are already know that you are here, and some government guy will know about you and always be informed and check you and will write and will request some information about you. It will be a really pain in the ass. So until you have a direct requirement to be fully compliant in the jurisdiction, you don't be in a haste here.
Thank you.
Yeah, don't speed up. It will be a pain in the ass for you here. And the other question is here that you never know how regulation will change in a few months. The really big problem on the blockchain projects. For example, we have third iteration of the revolution. First, if you have a business, you will create your business in your domestic town. For example, from New York, you create a business in New York, a shop in New York, a factory in New York. Okay. When the internet arises, we have some kind of problem that you have a company and it affects all the people in the world. So, data protection laws, domestic regulation, domestic registration, and the government are leveraged that through the banking. So, for example, somehow you need to money transfer and so on, and you were under pressure. But when the blockchain arises, you are no under pressure from this point of view, from the banking side. So you are creating a company in the internet, and you are making a financial institution that may work without any license and the government control. So you create a company in Estonia and work around the world. And this has a very big problem here with the law. For example, previous law was like that. If you create a money institution business, you create a company and a license here in this government. One government, one license. But when the crypto arises, for example, for first exchange, there was no license. And why you need to make a license everywhere in the world? It's no need, it's not problem. And I don't know how this problem will be solved, but at the moment, anyone who are in crypto space and making a big exchange have some big problems with law. And it's fully depends on the political wind.
Thank you.
Okay.
Very insightful. Thank you.
Okay, so our last conclusion is that haste makes waste, right? So, Orrin, you'd better not rush here.
Thank you.
Okay, Orrin, I hope that's been useful. So could
Definitely.
you share, let's say, the main lesson learned from today?
So many lessons.
Just pick
obviously, always get a professional legal opinion. It's hard to enforce patents. Make sure you're checking out the local security laws. Try to limit your direct facilitation of things and where you can have intermediaries. And just understand this landscape and don't make more problems for yourself, while also understanding the lay of the law legally in the textual landscape. Yeah.
Fantastic. That was a very good summary. Ruslan, could you please share the last piece of advice to our founders in general, who are just starting in the Web3 space, or probably already have their projects launched, but still do face some issues in the legal field?
Don't be scared. It's not so bad here in the crypto law. It's under development. And for example, even if you are not obeying the law, it really low chance that you will be persecuted. Don't be scared.
Awesome. A very positive note to conclude on. Guys, thank you very much for your time. Wish you a very nice day.
You too.
Yeah, thank you.
Thank
Bye.
you, everybody.